Hi guys. This is our last video that is going to go along with your textbook. So this video is going to cover just chapter 25, which deals with the legal concerns of being a personal trainer. So as far as that goes, there are three different types of law. So three different types of lawsuits that we could undergo. So the first one is called criminal lawsuits. So that's just being held legally accountable when we are breaking the law. So, for example, maybe selling controlled substances to your clients, or giving services, counseling services, and things of that nature that are outside of our scope of practice that require specific state licensure. So those are all things that we could be held legally accountable for, and that would be under that umbrella of criminal lawsuits. The next one would be contract law. Okay, and contract law is just that. It's, enforceable, that can include, breaking things like, waivers, informed consents, all the contracts, the legal documentation that we are, you know, having our clients fill out. So this is why I had said back when we were going through all those forms to, if you could have an attorney look through your forms and your documents just to make sure that they're, going to hold up in a court of law and they are, legally defensible for us. So if you know an attorney, that would be great. But, even sometimes paying just to have them look through those forms, if you're going to be doing this as a business, that probably would be a great idea because, again, contract law is a big one. So if you know of an attorney that is really good in contract law, that would be the person that you'd want to talk to. And then the third type of lawsuits that we see is the tort law, and that deals with acts of omission or commission that could result in injury or death. So, for example, maybe we tell our client to do a move or an exercise that's contraindicated, and that in fact led to the injury. We would be held legally accountable for that under that tort law system. So, or omission, maybe failing to tell our client to do something, and that failure led to their injury as well. So, acts of omission or acts of commission are would fall under that tort law. So, other legal concerns we have is staying within that standard of care. So, as a personal trainer, the NSCA has a strict standard of care. When you're certified through ACE, they have a strict standard of care, and it's actually stated within, the appendix of our textbook. So they do talk about that standard of care. Staying within that scope of practice, so the legal boundary that determines the extent of our professional duties. So not going outside of our scope of practice, and then following those statutory laws, the laws that are written by Congress or our specific state, making sure that we're following those laws. So in the court system, when we're looking at standard of care, the judge is going to have a lot of things that are factored into it. So number one, you've got expert witnesses out there who talk about policies and program guidelines. You have the actual recognized standards. What would what are the standards of the industry as it stands right now today? Position stands. What is the NSCA? What is the ACSM? Those big guys in this field. What's their position on this and their recommendations? And then obviously the jury. All of those things put together are going to determine if that personal trainer in fact upheld that standard of care that they were supposed to. So as far as legal, the biggest, probably the number one biggest thing that a personal trainer can see themselves in a lawsuit from is negligence. Okay, that's probably the biggest claim that clients do tend to have against personal trainers. And what negligence is it's the failure to conform one's conduct to a generally accepted standard, or it's the failure to act as a reasonably prudent person one would do under like circumstances. So what do other personal trainers in the industry do? So this can occur from many different things, one of which may be failing to perform something. So that's, like I said earlier, an act of omission. So not, um, requiring your clients to fill out the proper health history questionnaires or the PAR-Qs, to find out what their health history and their background is so we can give them proper programming. So omitting and failing to do something, or performing in a negligent manner, like teaching an unsafe technique. So that goes back to the act of commission. So telling them to do something when indeed they shouldn't have done that, and that led to the injury. So those are all ways that we can be found negligent as a personal trainer. So how can we minimize the effects of negligence or even avoid it altogether? Well, there's quite a few different things. Probably the biggest one is maintaining appropriate qualifications. So getting your certified personal trainer, it's a paper, right? Get that from the NSCA, okay, and maintain that certification. Getting your degree, right? That's going to help you to have further knowledge on what you should and shouldn't do in this field. So number one, having that qualification. Number two, providing pre-participation screening and waivers. We went through all of that, right? Getting the documentation, making sure that if they need medical clearance, you are, referring them to their physician so you can get clearance. You're doing informed consents with them so they know up front what's going to be going on. What are the hazards of this? What could occur? Making sure that we're staying within our scope of practice. Don't try to, educate your clients on things you do not know, right? Don't go outside that scope of practice. What you know is what you know, right? And if you're not sure, you need to refer them to the proper, health professionals, staying within that scope. Provide proper supervision, right? If we're going to be training a client, all eyes should be on the client at all times. Properly supervising them. We're instructing them on how to use the equipment in a safe and effective manner. We're going to make sure that the equipment is safe, right? Making sure that, it's not breaking down, or it's, going to falter and it's going to snap and break while they're using it. Of course, that's going to lead to injury. So we want to make sure that the equipment and the facility that they're training in is safe. We want to have an emergency plan in place. If we have our own facility, this goes back to that last chapter. So making sure that there's an emergency plan. Keeping detailed records. This is big because your detailed records, this can all be subpoenaed in a court. So you want to make sure, and that's why I've been really strict with you guys about keeping track of, what you're doing with your client for each individual workout, and make sure it's detailed. How many reps, how many sets, how much weight, being very specific. What was their exercise heart rate? All that detail needs to be in those records. And that can sometimes support us as far as, in a court of law. But also knowing that that's confidential information, so we can't share those records. We can't share any of the forms, the health histories, any of that stuff. It has to be confidential because this is personal health information that we're gathering. So we want to make sure that, we're not sharing that with anybody else. It's confidential information, unless, of course, it's subpoenaed in a court of law. Then we would have to share that with the judge. And obviously, maintain appropriate liability insurance. You'll see I have an assignment where I'm going to have you look at some different types of insurances. But if you're an independent contractor, you want to make sure that you have general liability or professional liability insurance. That way, if you do happen to get sued by a client, you have that insurance to protect you. So, making sure that you're checking those avenues out and obtaining that insurance. And when you do get certified through the NSCA, you have the option to buy what's called CPI. It's called Certified Professional Insurance, and it's around $350 a year, but it's up to $5 million in coverage. So that's something I would encourage you guys to look into if you're going to be doing a lot of personal training as an independent contractor. So again, confidentiality, I kind of talked about that a little bit, but you are handling, some personal health information. So we want to make sure that we are, keeping that under lock and key. So even at your house, you want to make sure that information is stored away safely so nobody else can get to it or see it. It shouldn't be just laying out on your desk for anybody that walks by to see. Also, don't ask your clients to be forthcoming with personal details. We don't need to know that much detail, although a lot of our clients want to think that we are, um, a psychologist and we do counseling. We do not do any of that stuff. So we don't want to, try to pry any of that stuff out of them, and don't ask for it. If you're using fitness results in advertising, include that in the informed consent. So if you want to use some of this data to advertise and market your brand and what you do, you need to make sure that you ask those clients ahead of time and say, hey, do you mind if I use your photos, or if I use, these numbers in my marketing campaign, so I can, show that I do get results. So you have to, get their approval and inform them up front about this, and get their okay. And so again, like I said, confidential records could be subpoenaed in a lawsuit. So any of this, even though it's confidential and we're, taking care to make sure that it's in a safe place, it can be subpoenaed in a court of law. So keep that all, in the back of your head. As far as litigation undergoing, in a lawsuit, employers can be held responsible for the duties of employed personal trainers. So if you are considered an employee and you do act negligently or something happens, your employer can also be held responsible in addition to you yourself. So, an employee and an independent contractor are two totally different things. So if you're hired as an independent contractor, that means you're mainly self-employed, right? You work within maybe a business, and I can go in and out of this business, and I can personal train as many people as I want, and I can charge whatever I want. I'm an independent contractor. Maybe I'm just renting their space for this period of time, but I kind of make my own hours. I, train as many clients as I want. I charge what I want. I work as many hours in a week as I want, okay? But maybe I'm just paying them a fee to utilize their space. If that's the case, they're not going to be held responsible for if I act negligently. That's all on me, okay? So if that's the case and you're an independent contractor, that's when you want to purchase your own liability insurance. So professional liability insurance is definitely what you need. Other things that might be of value would be health insurance, right? Or disability insurance. So if you get injured while you're on the job and you can't continue to personal train your clients, how are you going to pay your bills? How are you going to, put food on the table? So having the disability insurance gives you that money to help you to pay those. What if you get sick and you need to go to the doctor? Having health insurance can help you pay that, or pay for those bills as well. What was that? So, and responsibilities from for some duties of the manager, and that could be you, the person in charge, to regularly inspect, document, and label any damaged equipment, dangerous conditions. So, making sure that you're on top of, that equipment, and that we're not going to injure, those clients aren't going to get injured as a result of using that equipment. So these are just some different claims that have been out there as far as court battles with clients and personal trainers. So there's quite a few different things listed here. But like I said, the most common claim in a court of law against personal trainers is usually liability, or is usually negligence. So again, that just goes back to making sure we're acting in a reasonable and prudent manner, making sure we're upholding the standard of care, we're staying within our scope of practice. Those sorts of things can help us reduce those claims of negligence. So what should we avoid? Obviously, personal relationships with our clients and other staff where you work. So that's something definitely is a no-no. We should avoid doing any counseling of any sort to our clients. That's not what we're here for, right? We're here for personal training, not for counseling. So, we can listen to our clients, but, if we detect, hey, they need maybe some additional help, we can refer them to the appropriate professional as far as that goes. But if we do tend to, a client tells us something that may be personal, definitely document it, and just keep a record of it, so that way if we do happen to get pulled into a lawsuit, we do have documentation that, hey, they did say this, but I did refer them, to this health professional as a result of that. So, Chapter 25 deals with a lot of that legal stuff. I do provide quite a few different articles and assignments that you're going to be doing for this chapter as well, but all important, valid concerns, especially if you're going to be an independent contractor, which I'm thinking many of you are thinking about going that route. So, you want to definitely keep the legal part of it in the back of your head too.